All right, folks, it's time for our favorite podcast, Cut to the Chase, with Mike Burns. How you doing, Mike?
Happy holidays to you, Greg. It's nice to be your guest on a holiday version of Cut to the Chase.
All right.
Santa's made it all the way back home, and everybody's got the menorah lit, and so it's just great to be with you.
Yeah. No, I was looking at my calendar on the computer. I think today is Kwanzaa Day, and you actually told me today was also Boxing Day in England.
Boxing Day in England, where they throw out all the boxes from all the presents yesterday.
Yeah, wow, the landfills must be like jumping for joy with all that. And I'm going to get this thing up before the end of the year, so it's like the holiday special 3M update. I think a lot of people were like, all locked in, and then it's like, what now? It's been like 2 months, nobody's heard anything. So I brought Mike back, co-liaison counsel with Mostyn Law Firm. He's the man that knows as much as there is to know about it. So we gotta, get everybody caught up to speed, like what's going on. Are you ready to do that?
I'm ready to do it, Greg, and I appreciate you having me back on the show and our conversations that we've had earlier this week in reference to Judge Rogers, who just entered an order on the 3M cases. And I know, and we want all the plaintiffs out there to know that Judge Rogers had stayed all the cases in the MDL, the multi-district litigation as it applies to 3M, because cases were on appeal, whether it was the cases where the plaintiffs won for jury verdicts equaling almost $300 million, or the big one, the government contractor defense case. That's on appeal to the 11th Circuit. And Judge Rogers went ahead and stayed everything because she didn't want to put everybody through the paces and then have something reversed and impact the entire litigation. So what she did is she stayed all the cases in that case, hoping that we would get a ruling very soon from the 11th Circuit Court of Appeals. And also, Greg, the thing that you and I spoke about earlier this week, she made a ruling as to liability in all of the cases, all the past cases and all the cases moving forward, that 3M is liable for all the damages in all those cases. Because when we went try these 19 bellwether cases, 3M had never said that they were not liable for the damages caused by the CAE V2, the Combat Arms Earplug version 2. They assumed and admitted liability in all those cases. And even in one of the cases, Greg, and I know you're familiar with this, that I think it was the Colorado case, the Wayman case that we won. They went back and they argued before the court that there was only one person that was liable, or one company that was liable, and that was 3M, because they didn't want a multiplier to be applied to that case, which would have been, if I'm not mistaken, Greg, correct me if I'm wrong, I think it would have been 6, because there were 6 entities that were involved. And so it would have been the damages times 6. And 3M said, oh no, Judge, there's only one involved, and that's 3M. And then, and I know, they filed their bankruptcy petition, which the bankruptcy judge said this is a complete farce, and said nope, it doesn't apply to 3M. And so Judge Rogers basically said, you can't have it both ways. You have acted in bad faith. And that's what she said in her order the other day. She said that, mass torts litigation is not for the faint of heart. And she meant that when she said it. And so she's asked the 11th Circuit Court to take her order up on appeal. She wants a ruling. Hey, go ahead. Here's my order. I say that 3M is liable for all the damages independently, and 11th Circuit, come on and tee it up and make a ruling on this. So that's an interlocutory appeal, a case that's being sent up to the 11th Circuit, and she's asking them to make a ruling on that. So still, even though it's a holiday season, and I know I've said a lot, there's a lot going on still in 3M.
All right. So listen, we're going to try to break this down, because this is the largest mass tort ever, 230,000 or so vets in this case. And I know a lot of people are like, oh my God, I'm trying to call my lawyer. I don't know what's going on. Oh my God, I'm seeing all these victories. When am I going to get paid? When is it going to get settled? People are, the total amount of victories. 13 plaintiffs have won, 13 veterans have won, 19 veterans have gone to trial. There were 16 trials. A few of them had multiple plaintiffs involved. The total amount of damages awarded is $300,000 some people are like, wow, I'll take $1 million. I'm sorry,
300 million.
300 million. I'll take $1 million and be done with it. And now you're talking about appeals, stays, interlocutory appeals, and the judge issuing this order, and like there's so many moving parts. So I'm going to try to help you simplify this to the degree possible. Okay. So first, what I'm going to do is I'm going to do a little bit of a timeline. We're going to break it down piece by piece, and then try to like establish where we are, what the next things are that have to happen to proceed. So, okay, we're 2008. There's a company called Aearo Technologies. They are manufacturing this earplug, the dual-ended Combat Earplug that, is not working, and they don't explain how to work it. And, people are, a million, our Army personnel are out there. Bombs are going all over the place. They have these earplugs and they think they're being saved. No, they're not. So 2008, 3M buys out Aearo Technologies.
That's correct.
Buy out all of the assets and all of the liabilities of Aearo Technologies, which essentially were these earplugs. Aearo Technology now becomes a subsidiary of 3M, but they're not really doing anything. They're not continuing to make the earplugs. 3M then from 2008 to 2015 is making the earplugs. Somebody blows the whistle, that ends. They stop selling that earplug to the Army, because at that point, then the cat's out of the bag. Everybody, knows, at least the Army and 3M know that everybody knows that these earplugs are not working. Whistleblower case takes a couple of years. Finally, that becomes public knowledge. All the mass tort lawyers are like, whoa, what's going on here? And the litigation begins. Now the litigation begins. We have these 19 trials, 13 victories. Everybody that has won their case, has 3M appealed those decisions, those verdicts?
That's correct. All those decisions have been appealed.
Okay, so we have all these things that are going on in appeal. All right. None of these appeals has finished. So nobody has gotten a final result.
Correct.
Okay, so now the judge, basically mass tort world, judge sets up what we call bellwether trials, cases, good examples, good, bad for both sides. So you're supposed to try maybe 3 to 5. Everybody kind of sees what's going on, and then they settle. But that didn't work here because it's so big, so voluminous. God only knows what's going on in, the boardrooms at 3M and how they're strategizing all this. But they can't be too happy. How much money, by the way, do we know how much money they paid their law firms to defend all these cases?
Greg, they were paying over $1 million a month to some of these law firms, and that doesn't count the cost of the trial preps, just to handle whether it was taking depositions. So, I mean, you got to look at it this way. It's been a cash cow for the defense bar that have been handling these cases, whether it be the expert depositions, the doctor depositions, getting ready for trials. 3M's been spending millions and millions of dollars defending this litigation. Okay,
so now in all these cases, what has happened is the lawyers for 3M, who are also the lawyers for Aearo Technology, they were named as a defendant in these litigations because the plaintiffs always want to cover all their bases, and they don't want to not name a potential defendant and then find out that that's the real entity. So the lawyers for 3M and Aearo Technologies make what we call a representation to the court. And they say 3M is the party that's responsible for all of these earplugs, whether
that's correct.
2008 and before or not. So the judge, everybody's relying on this. You're kind of stuck with this. So now the bellwether phase ends. The judge is hoping she appoints someone to try to mediate this whole matter. That doesn't go anywhere. And she's hoping to get the cases settled. And at that point in the mass tort world, when that doesn't happen, the judges oftentimes will send all the other cases back to where they originated. And those judges take over. And it's like, okay, here we go. There's no mass settlement. So now we're going to go at it one at a time. So now she's starting that process. And then 3M's subsidiary, Aearo Technologies, files for bankruptcy and asks the judge, the bankruptcy court, to say, all right, our bankruptcy, which by law stops all the litigation against us, well, we wanted to stop against 3M.
Correct.
And that's the bankruptcy court said, well, 3M can file bankruptcy themselves because when you do that, your operation ceases. You basically take your assets, your liabilities, your operation, and you are giving them to the bankruptcy court. They appoint a trustee and the trustee takes over. And now you got to file all these schedules and you got to stop paying dividends and you got to stop paying your bills and all that and let the bankruptcy court assess what's going on. But they try to have their cake and eat it too, is what you're telling us. When the Aearo Technology files for bankruptcy and says, oh, judge, stop all the cases against 3M. And so everybody's, I mean, the Judge Rogers is, you got to be kidding me. You told me that 3M is the party responsible. And the bankruptcy court said, no go. 3M, you're on the hook. Let's go forward. And then 3M decides to take an appeal to the bankruptcy court, the higher bankruptcy court, on this issue. Or did Aearo take the appeal?
Aearo took the appeal because 3M was not a party in the bankruptcy matter. But what was interesting, one of the parts that kind of blew up on 3M is they entered into a funding agreement with Aearo that they would be liable for all of the expenses for Aearo as it related to the bankruptcy and as it related to the settlement. So 3M was trying to have its cake and eat it too and be in two places at one time, get out of the MDL in front of Judge Rogers and go over there and settle the case in the bankruptcy court. That particular issue, that is on appeal too over in the 8th Circuit in Indiana. But what's still going on, Greg, and you've mentioned it, is Judge Rogers is doing whatever she can do as to having the plaintiffs and the defendants enter into mediation. That was part of her order that she tried to enter at one point, having the parties meet once a month to resolve this particular issue. So what we're waiting on the 11th Circuit to make a ruling. And at the same time, Judge Rogers sent up this most recent order that she just entered right before the holidays. I want to say it was around the 22nd and 23rd, asking the 11th Circuit to take a look at the issue on independent liability and how it applies to 3M. So we got a lot of things will probably be breaking in 2023, which is just a couple of days away. And I appreciate you bringing me on Cut to the Chase. I had a client call me the other day and said, hey, I saw your latest show on Cut to the Chase. He goes, it was very informative. So Greg, you're really doing a great service out there, putting this out there for all the soldiers, the vets, and active duty, because we have both active duty and vets that are involved in this litigation.
Yes. All right. So now we're getting close to that order the judge signed. We'll get a little bit into the details of that. So we have the trials that are in appeal, right, in the 11th Circuit. So the cases are in front of Judge Rogers, who's in the Northern District of Florida. So when her decisions or any cases in federal court in Florida get appealed, it goes to the 11th Circuit Court of Appeals, which also covers Georgia. And is it Alabama? How many other states do they cover?
I know Alabama, and I'm not sure what other states are included. Alabama, Georgia, and Florida, I know those three are included in the 11th Circuit.
Yeah, and we like to say down here that Miami is its own state, but okay, for purposes of the legalese. All right, so you've got all these appeals going on in the 11th Circuit, and we've already talked about this before. The main common issue on all of those appeals is the government contractor defense.
Correct.
Basically saying we design these earplugs to the specifications provided by the Army, and therefore we're not responsible if they were defective. And
that's 3M's argument. Correct.
Did they? Is that the case?
That's there's no contract. There's no contract between the Army and 3M. You would think that in a government contractor's defense, that would be the first thing that you put in there is the contract saying, here's what we want you to design. But there is no contract. And that's the interesting thing, that 3M's hoping that they can take this appeal up even maybe further, because this issue has not been resolved by the U.S. Supreme Court, let alone by the 11th Circuit. So it's going to be interesting to see how the 11th Circuit rules. I think Judge Rogers' order has been pretty tight, and I would strongly believe that they're going to come back with a similar ruling as Judge Rogers.
All right, so is the 11th Circuit, are any of the cases that are up on appeal there, like, normally the parties, the plaintiff and the defendant will file written briefs. They'll say, here's why the judge was wrong, here's why the judge was right. And then oftentimes the court will have oral argument and then make a decision. That's the typical process. Yeah, I mean, that's a very simplified way of explaining the appellate court. But are any of the 13 cases that are up on appeal, or 10 or what, however many, which have the government contractor defense, have any of them had oral arguments? Is there any, like, in your mind, is there any of them that look like it could have a decision?
I don't think there's any arguments pending before the 11th Circuit as it relates to the government contractor defense. However, that they have those, they have the defenses. I believe that was argued in the past, and so all that is already concluded, and we're just waiting for the 11th Circuit to make a ruling.
Okay, and so besides the 11th Circuit Court of Appeals, you have the bankruptcy, the 8th Circuit Court of Appeals that's deciding the bankruptcy issue that Aearo threw out there, that said that 3M should, be entitled to bankruptcy even if they didn't file for it.
That's correct.
All right, and is that, from what I was told, that was put on an expedited track? Meaning
That's correct as well.
So that bankruptcy court wants to make a decision on that relatively quickly.
That's correct as well.
All right, and that kind of dovetails into the order that the judge just entered, which is, who's the responsible party for these earplugs? And she decided on her own to enter an order saying 3M's responsible.
That's right. And in that order, Greg, she basically said the plaintiffs, 3M took the position that they were the liable party. And so that precluded the plaintiffs from making that argument in those 19 bellwether cases. So that argument has gone away. And now 3M at the end of the day says, hey, we should have severed the liability, and Aearo should have been responsible up to this point, and 3M should have been responsible after that point. I think that point was 2008 is what 3M is claiming. They should be 2008 forward, and Aearo should be 2008 and before.
All right, yeah, because that's the date that Aearo sold to 3M, and 3M took over and started to make those. So even if they would somehow or another, Aearo or 3M win that issue, that only talks about the cases for the vets from 2008 before.
That is correct.
It's not, so for vets that, like 2008 and on, you don't necessarily have to worry about that. But the reality is, you go to trial, one side says, Judge, hey, we're responsible. The other side says, okay, we don't have to prove that, right?
Correct.
And
correct.
so you can't come back later on and say, oh, by the way, we were just kidding. You never proved your case. We win. I mean, that's what it sounds like they're doing.
That's exactly right. So basically, they have said that we're the ones that have been responsible for the liability, and Aearo never showed up at trial. In all the trials, 3M basically is admitting that they're the ones that are liable for the damages, or they're the ones, they're the ones that are going to cut the check. So they didn't try to sever the liability.
All right. So as far as you know, is the 11th Circuit waiting for the bankruptcy court to make their decision, or do you think they're both just going to go on their own? And
I think they're both going to go on their own. I think the 11th Circuit is going to make their rulings as it applies to the government contractor defense and as it applies to the interlocutory appeal.
So let's say the 13 plaintiffs, veterans that have won, that are on appeal right now, win their appeals. The government contractor defense gets shot down. The Supreme Court says they don't even want to entertain it. You didn't even have a contract. This is a terrible case for us to even look at, at this level, which is, to me, what sounds like what would happen, but who knows? All right. So if they win, does the decision from the bankruptcy court, would that affect their outcome?
It could affect anybody whose cases was 2008 or before in those cases. And I'd have to go back and look in the weeds to see which one of those clients' cases were 2008 or before. But it could, depending on the ruling by the bankruptcy court as well, or the
Right, so the issue with the order that the judge enters saying, okay, I'm going to make a decision right now and end this discussion once and for all. 3M is the responsible party. She then says, go ahead. This is an interlocutory appeal because it's not at the end of the case. It's during one of the, did she do it in one particular case or did she do it at, in mass?
Greg, I'd have to go back and look at the order that she issued. I think it was on the 22nd when she issued that order, but she did ask the case, I believe, now I would have to go back and look at the particular order, that she applied it to all the cases that went before and all the cases in the MDL subsequently. So she wants the 11th Circuit to make that decision. Does it apply to all these cases here? Because plaintiffs were basically barred from making that argument in the previous cases. And so that's what plaintiffs made a motion to basically say, hey, 3M's liable on all these cases going forward. And that's what she did, is she made a motion, ruled, granted an order, a motion for summary judgment on that issue as to plaintiffs that 3M is liable on all the cases in the past and all the cases going forward, and asked the 11th Circuit, hey, am I right on this? Make a ruling on this and send it back to me as quickly as possible.
Yeah, normally a party that loses is the one that has to make the request the appeal. In this particular case, the judge is trying to do what we call conserving judicial resources and streamlining this issue so that in the future, if we're going to have to go forward with 230,000 cases, we're not sitting here, everybody trying, taking 2 or 3 days out of a trial to prove a point that really doesn't even exist.
Correct. That's exactly right.
So, and the last part of this discussion today is you said Judge Rogers entered a stay on all the cases.
That's
so
correct.
Stay sounds simple, but it's a fancy legal word. What does that mean?
Well, that basically means nothing's going on. Everything just comes to a stop. And Greg, despite COVID and everything that was going around the country the last 3 years, the 3M mass tort litigation has been moving at rocket speed. When you have close to, at one point, almost 300,000 cases, Judge Rogers has dismissed cases. She's taken cases and required the plaintiffs to file cases. She's taken cases off the administrative docket and put them onto the active federal docket. She's tried 19 plaintiffs' cases with 16 trials, consolidated trials. It has been going at rocket speed as far as, like you said earlier, you think most people try 3 to 5 cases in an MDL, multi-district litigation. In this case, there were 19 plaintiffs that went to trial, 16 trials, consolidated trials with multiple plaintiffs. And so now everything is grinded to a halt. She's issued 3 waive orders, which waive orders were 500 cases at a time, having plaintiffs and defendants work those cases up for trial. And she was going to do, like you said earlier, remand those cases, send those cases back to the jurisdictions where they would have proper venue, where that case could be trial, and have those cases set on a trial docket and move forward.
All right. So basically we're waiting for the 11th Circuit on their government contractor issue.
That's the big issue. Yep.
All right. And then the other issue is the bankruptcy court and whether 3M gets bankruptcy protection, based upon Aearo's filing for bankruptcy.
That's correct. And once again, back in the 11th Circuit, the interlocutory appeal on whether or not 3M is solely liable for all the claims again on the earplugs.
You mentioned that the judge had ordered the parties to mediate every month. Is that order still in effect?
That order is still in effect. That's correct.
So when would the next mediation take place?
In January.
Okay. And I know that it's all confidential, so I'm not going to ask you any more questions on that. And is there anything else that the audience should know about to try to help them? I guess, everybody's in a sit and wait pattern, right?
That's pretty much it. But if they have any questions, reach out to yourself, reach out to me, give me a call at Mostyn Law, and or give Greg a call, and we'll be glad to answer your individual questions if we can.
And I've been throwing these episodes out on my YouTube channel. So people have been asking questions on the YouTube channel. I know somebody asked a question a couple of days ago I need to answer, but that's also a way for you to ask me questions. And if I don't know the answer, I just call Mike up and he's like, Greg, Please, can we just keep this to once a month? No, I'm kidding. All right, listen, Mike, God bless you. I was it's so cold in Miami right now, 57 degrees. I actually turned my heater on, but I don't think my air conditioning unit, it doesn't understand what heat is. I mean, it still feels like 50. Anyway, all right, everybody, I'm going to say it, happy holidays. I hope that's not offensive. Mike.
Not offensive, Greg. Thank you so much. We wish you and your family happy holidays as well.
All right, and next year you will come down my chimney. I know you're probably surfing with this polar vortex or whatever, but that'll, we'll save that for next year. All right, everybody, that's it for this episode of Cuts to the Chase. You know what to do. Share, rate, review, leave questions, YouTube channel, wherever you want to do it. Call me up, call Mike up. I'll put his link in again. I'll put some information up on the latest order in case, there's some lawyers or people that love the law and want to see what Judge Rogers wrote up, which was a fascinating order. And it was actually kind of, not as cut and dried as most judges, right? I mean, that was a little colorful.
Little color. That's right. It's the holiday season.
Yeah. So maybe you're a law student or you just started law, as a lawyer or whatever, and you want to see like what an order, an interlocutory appeal, would look like or whatever. But, check that out. All right, folks, that'll do it. Enjoy your holidays. Mike, Happy New Year. All right. Thanks for coming on.
Thanks, Greg. See you, buddy.